The decision invalidating a section of the Voting Rights Act of 1965 deeply divided the justices, but it rested on a simple premise. As Chief Justice John Roberts said, nearly 50 years later, things have changed dramatically. At issue was a provision in the act that singled out states with a history of discrimination in voting, mostly in the South, and required them to get pre-clearance, approval from the federal government before changing voting procedures. Officials in Shelby County, Alabama, challenged that provision, arguing the South had made great progress since the act became law, and today should be treated like the rest of the country. In its 5-4 decision, the court said Shelby County had a point, and the justices turned the spotlight squarely on Congress, saying it was wrong to use a decades-old formula to keep the same states under federal oversight. When Congress reauthorized the Voting Rights Act in 2006, it continued to rely on rates of minority voter registration and turnout from the 1960s and early 1970s instead of using current data. History did not end in 1965, the court said. In the years since, voting tests were abolished, disparities in voter registration and turnout due to race were erased, and African Americans attained political office in record numbers. But Justice Ruth Bader Ginsburg, joined by the 3 other liberal justices, said Congress assembled volumes of evidence to show federal oversight in the covered jurisdictions worked, and that without it, the covered states could revert back to their old ways. Throwing out pre-clearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet. But today's ruling means those covered states and local governments are now free from federal oversight. They can immediately change their voting laws and their procedures without having to come here to Washington to get approval first. Unless Congress can rework that formula to set which states are going to be covered. And everyone today, the consensus is Congress is never going to be able to agree on that. So that means that you're still going to be able to sue if these laws intentionally discriminate against minorities, but those pre-clearance requirements, well, they're all but dead.
And the president said today he was very disappointed by the decision. Jan, thanks very much.